The Democratic whip.
Mr. President, I listened carefully to the presentation by my colleague and friend, Senator Graham of South Carolina. I wanted to come to the floor to make it clear that he didn't tell you the whole story. In fact, in some ways, he didn't even get close. Who is this Judge, Ketanji Brown Jackson? How could she even be considered for the Supreme Court if she is the preferred pick of the radical left? Well, let's take a look at her background. An extraordinary story of a daughter of two public school teachers, the daughter of a father who decided he was going to go to law school, basically stopped working full-time. His mother supported the family, her mother supported the family. She was a little girl at the time. She remembers it well because there'd be law books stacked on the kitchen table. She would come in and, as a little girl, bring her coloring books to sit next to her daddy while he was studying for law school. He went on to become a lawyer. Family members were policemen. One of her uncles turned out to be the chief of police in Miami. She grew up in a very ambitious, determined, orderly family, and she certainly had a respect for her family ties to law enforcement. She was on the debate team in high school, and one of the trips took her from Florida up to the campus of Harvard University. She was dazzled, believed that this just might be the answer to her dreams. Came back to her high school and sat down with her high school counselor, who said to this young black woman, "Honey, you're shooting too high. I don't want your heart to be broken. Think about other schools. Don't think about that Harvard University school." Luckily, she ignored that advice, applied, and was accepted. She told the story before the hearing about being on the campus at Cambridge. Not sure that it was the right decision. Looking around, seeing a much different world than the one she grew up in, and a much different group of people than she was used to socializing with. And she must have shown it in her face, because as she was walking across the campus one day, an African-American woman saw her, looked at her, and said, "Persevere, persevere." Just that simple word captured everything for her, and she did. She persevered and completed her education at Harvard and went on to Harvard Law School. She was an outstanding student at the law school, so much so that she became a clerk to the federal district court, did such a good job she was promoted to become a federal circuit court clerk, and then the ultimate prize for any graduating law student in America, clerk to a justice of the Supreme Court, Ketanji Brown Jackson. And what an irony that she worked for Judge Stephen Breyer, whose retirement has created the vacancy which she seeks. Along the way, she staffed the Sentencing Commission. She worked in the Public Defender's Office. She became the federal district court judge, cleared by this committee, Judiciary Committee. This was her fourth time before the committee. Each time she appeared, bipartisan support, including the senator who just spoke against her. And then ultimately, the opportunity of a lifetime to fill a vacancy on the Supreme Court. For the hearing itself, first I want to commend my Republican colleague, Chuck Grassley. A chairman of a committee, a Democrat, couldn't be any luckier than to have sitting in the chair next to you, Chuck Grassley. He's a gentleman. He's a strong, faithful Republican, but he's a gentleman. And we were determined to make this hearing for this judicial nomination to the Supreme Court different than some that had gone before. And I want to commend the Republicans on the committee. There are 11 of them. The majority of those Republicans asked tough, probing questions, as they should. They never got personal. They never raised their voice. They were respectful throughout, a majority of them. I'm sorry to say that in a few instances there were exceptions on that side of the aisle. But I think the hearing, by and large, was a good hearing, despite a few differences, which I'll note in a minute. And at the end of the day, you could not help but leave that hearing and think you had just witnessed a moment in history. Not just the first African American to aspire to serve on the Supreme Court, but also a pillar of strength during her hearing. They threw it at her in every direction. I can't tell you how many people have come up to me everywhere I've gone since that hearing and said the same thing. How did you sit through that? How could you put up with it? And I said to them, think about her, sitting in front of her husband and her daughters, some of the things that were said about her, said again this morning on the Senate floor. She came out a pillar of strength, grace and dignity under pressure. I looked up at that table several times and thought, Judge, if you stood up at this moment and said, enough, I'm taking my family, we're out of here, I would understand. But she never did. She never wavered. She was solid as a rock, and that's why it is my honor to support her and believe that she's going to make history. Some of the things they said were outrageous. This case they want to make about her sentencing guidelines when it comes to sex crimes involving children and child pornography. What did she say about it? She said they were horrible and despicable crimes, but she didn't just say it before the committee when she was under assault. Listen to what she said in one of her cases, United States versus Hilly, a case involving this sexual misconduct toward children. The true nature of these offenses, Judge Ketanji Brown Jackson said, lies in how they affected the children who you tormented for nearly a decade when you lived on and off with their mother. That is a substantial portion of their childhood. These two children carried a burden no child should have to shoulder, the burden of protecting themselves from a man charged with their care, but who instead exploited them. And then she went on to say, this family has been torn apart, she said to the defendant, by your criminal actions. You saw it on the faces of those women, you heard it in their voices, and the impact of your acts on these real victims who are still struggling to recover to this day makes your crimes among the most serious criminal offenses this court has ever sentenced. Does that sound like she's soft on crime? Does that sound like she didn't remember she's a mother of daughters and cared for the impact those crimes had on the children and the family? Not in any way whatsoever. You would draw a much different conclusion if you just listened to the arguments being made recently here on the floor. And it would be an unfair conclusion. The bottom line, as far as I'm concerned, is this. What they've left out in the presentation is critical to the very truth of their allegations. Judge Ketanji Brown Jackson is in the mainstream of sentencing when it comes to these cases. 70 to 80% of federal judges divert from the guidelines, as she has in some cases. And let me add, her accusers have been voting for federal judges proposed by President Trump, right and left, who do exactly the same thing she does. I asked consent to enter into the record a New York Times article of March 25th, 2022, entitled, Jackson's Critics Back Judges with Like Rulings.
Without objection.
It tells a story, and the story is very clear. We have a situation in this country where we have not upgraded the child pornography and sexual misconduct statutes in years. Across the board, 70 to 80% of federal judges take the same position as Judge Ketanji Brown Jackson. These so-called deviations from the guidelines has become commonplace. As I said, the overwhelming majority of federal judges are doing this. Was there a problem? There is. But the problem is that we have not upgraded the statute. We bear responsibility for this. The decision was made before the Supreme Court that these guidelines would not be mandatory. It was a decision joined by Anton Scalia, the originalist, the conservative. It put the burden back on Congress, and we have not picked up that responsibility. So you say to yourself, well, if she were so soft on crime, it surely would have shown up in other places. Well, let me tell you what happened. The American Bar Association did a review of her career as a prosecutor, as a defender, on the bench. They interviewed 250 individuals, judges, prosecutors, defense lawyers, other counsel who'd worked with her. And I asked point blank Justice Ann Williams, who led this investigation by the ABA, Did you hear from anyone who said she was soft on crime, that she somehow was not in the norm when it came to sentencing? None, not one. 250 people interviewed, not one came up with it. All we've heard against her has come out of the mouths of 3 or 4 people in the committee, and that's it, because there is no record for it. Well, how did the American Bar Association grade her when it was all said and done? Unanimously well qualified. Unanimously well qualified. Doesn't sound like the same person who just described, does it? Because it isn't. What you've heard on the floor here is a mischaracterization of her record. I'm sorry to say it's unfair, and I wish it hadn't been part of the record today. What about Guantanamo? Well, I have some serious differences with the senator from South Carolina about Guantanamo. Hundreds of detainees have been sent through Guantanamo since the War on Terror began. Many of them should have been there. But hundreds and hundreds of them have been released by presidents, Republican and Democrat. We're now down to 39 detainees. We're spending over $10 million for each one of them each year at Guantanamo Bay. And when it comes to the resolution of who was responsible for 9/11, the families have come and testified before us. They've waited over 20 years and they still don't have an answer. They understand that the approach at Guantanamo Bay is not leading to justice. It's not answering the basic factual questions. So what is her situation? Why would she dare to call the Republican president of the United States a war criminal? What was she thinking? Well, it sounds like a terrible charge until you read the facts. And the facts were she presented a brief. And the brief referred to a body of law known as the Alien Tort Statute. And the person she was representing in this brief was arguing that he was tortured, mistreated at Guantanamo Bay. And so he filed a claim under the Alien Tort Statute. And when you do that, you sue the President of the United States and the Secretary of Defense. They were the named defendants. It included President Bush. What the senator from South Carolina failed to disclose was that as that case was winding its way through, the administration changed. And if there was an allegation of war crime against President Bush, it was the same allegation that was made when the administration changed and the name of the defendant changed to Barack Obama. To argue that this was a personal charge against the President of the United States as a war criminal is a gross exaggeration and unfair on its face. The named defendants were required under the Alien Tort Statute for the allegations that were made. That wasn't her decision. That was a decision of Congress to write the specifics of the Alien Tort Statute. The third point I want to make is immigration. Yes, we have challenges in immigration. I think we all know it. But to blame her and say that she's somehow responsible for the invasion, you saw the crowd of people coming across the border, is really unfair. What happened was there was a lawsuit filed challenging a Trump decision on policy, and she was asked to rule on it. And she ruled in one direction, the appeal was taken, and she was reversed at the circuit court. Now, according to the senator who just made the presentation, evidence she's in the pocket of the radical left when it comes to immigration, evidence that George Soros somehow is controlling her decisions. It's preposterous. The fact of the matter is, if you look at almost 600 decisions handed down by Judge Ketanji Brown Jackson, you will find a small percentage that were actually reversed. And if you're looking for a second case to build the theory that she's on the radical left, I don't even think you found the first one. She has a balanced approach. She's ruled for and against Democrat and Republican presidents. She has shown the kind of balance we expect on the Supreme Court. I would say this notion that somehow Joe Biden has chosen someone who is radical is a shame. She's not. She is as solid as they come. And her testimony and her appearance before the committee proved that over and over again. And I also want to say I have nothing against the South Carolina judge who was in the finals but wasn't chosen by the president. In fact, President Biden has asked that she be promoted from the federal district court to the federal circuit court, and I'd like to get that done as quickly as we can. I think Judge Childs is well deserving of that opportunity. She certainly is a good jurist. But the choice by President Biden was clear, and it was the right choice. These charges that somehow she's soft on crime because she's an African-American woman and she was a public defender belie the actual record of this woman. We should all be judged on our records. This notion that we're asked to identify ourselves by labels, we know that story, the 100 of us who sit on this side of the chamber in the Senate. We are attached to labels which we embrace and some we don't embrace. But most people who are fair will say, I'm not going to judge you by your label, I'm going to judge you by your record. If you judge Ketanji Brown Jackson by her record, written opinions, the fact that this was the 4th time she appeared before the Judiciary Committee and been approved the 3 previous times, serving on the Sentence Commission and so many other things, you know that is an outstanding and stellar record, but you know it almost has to be. If you want to be the first, you have to be the best. She is the best. Despite some of the things that have been thrown at her today and in other places, the American people came out of that hearing and felt better and stronger about her nomination than before the hearing began. It is evidence of the strength that she brings to this nomination and the value that she will bring to the Supreme Court. I yield the floor.